far you have come on your own, but never alone. Through the rain and through the shine, here's your moment, it's your time. You stood tall and now you see, standing in your destiny. 100 women growing strong. 100 women where you belong. You stood tall and now you see, you have reached your destiny. Woman, woman.
As people of African descent, we offer this land recognition in solidarity with the indigenous peoples of Turtle Island in the efforts and deliberate intentions toward decolonization. As people of African descent, we acknowledge the land of Turtle Island that sustains us, express deep gratitude to its indigenous peoples, and pledge to honor our dignity and divinity that ultimately connects us all. By Kay Johnson. Welcome to 100 ABC Fireside Chats. 100 Accomplished Black Canadian Women is a bold project initiated by co-authors and co-founders, the Honorable Dr. Jean Augustine, Dr. Denise O'Neill Green, and Donna Jones Simmons. Our mission is to celebrate and archive the professional accomplishments of trailblazing Black women from all across Canada. The goal is to create an ever-expanding database available for current and future generations via print media, public and private libraries, as well as our website, which is www.100abcwomen.ca. In addition to our fireside chats on topics that matter to our communities, such as education, healthcare, entertainment, creative arts, trade union, and so much more, we offer biennial book launching galas and biannual symposiums. The co-authors and co-founders would like to take this opportunity to thank each of you for attending today's fireside chat. We know that you will find these sessions educational and inspirational. So sit back, relax, and hear from our brilliant and talented honorees. We absolutely cannot thank our sponsors enough for making these fireside chats possible. Thank you. Good day, everyone, and Happy New Year. I'm Donna Jones Simmons, co-author, co-founder, and the architect of the 100 ABC Women Project. Today's conversation is about creating your will with panelists Thora Espinet and Estella Miyonda, who are lawyers and will speak to this topic. Today's inspirational conversation is being moderated by Sarah Onyango. She's a TV and radio host, as well as a professional translator. Today, I'm sure you will hear some stories and scenarios as to why you need to have a will and the importance of having a power of attorney. So, over to you, Sarah.
Thank you, Donna, and hello, everybody. Thank you for joining us for this very important conversation. Listen, more than 58% of Canadians say they have a good level of estate planning fundamentals. 52% still don't have a will, and that number jumps to 70% for those ages 18 to 34 and 66% for those 35 to 54. That's from an article published in July 2022. Has your lawyer ever said to you, the will is the will, and you didn't understand what they were saying? Well, we've got two experts, two legal experts, Thora Espinet and Estella Muyinda, as Donna just mentioned. And they are going to talk to us about why creating your will save your family or loved ones lots of headaches in the long run. Estella Muyinda is a consultant and investigator and a partner at Notaries Canada Corp. She was called to the Bar Societies of Ontario in 2004, Northwest Territories in 1995, and Manitoba in 1993. She is the ambassador of the Kingdom of Buganda to Canada. Estella sits on the board of the Canadian Centre for Victims of Torture. She's the founder of the BEAN 5K Walk Run for Mental Health Awareness, HIV/AIDS, sickle cells, and fistula, and a proud 2018 100 ABC Women nominee. And you will see that her dispute resolution experience will come in handy in this discussion. Welcome, Estella. Thora Espinet is a retired deputy judge and a part-time practicing lawyer. She was called to the Bar of Ontario in 1984. She's an active participant in the community and has sat on numerous boards, including Humber College. Thora has been the recipient of numerous awards from the community, which include the Lincoln Alexander Award from the then Law Society of Upper Canada. The University of Windsor has honored her with a scholarship in her name for Black law students. Now, before we start this very important conversation, I'd really like to remind our audience that this conversation really is for information purposes only and does not constitute official legal advice. Okay, so we do encourage you to consult a lawyer in your province for legal advice. So let's get right into it. Estella, what is a will?
Thank you so much, and thank you for this opportunity to be part of 100 BC Women. I will start by saying that a will is a legal document that declares your last wishes. It is the instructions you leave behind with direction on what should happen to your possessions, especially how you want your estate to be distributed. That is after your death. It is good to have a primary will for assets that require probate, and a secondary will for assets that do not require probate. Probate is the court procedure for formal approval of the will by the courts as the valid last will of the deceased and appointment of the person who will act as the executor of the estate. If your estate has assets and they're all gifted in one will, they are of a higher value and will pay more taxes as per the tax is calculated only on the value of assets in the primary will. So the purpose of having a primary and secondary will is to separate the assets requiring probate from those that do not require probate, such as personal and household effects, and your shares of private corporations if you have any. If you make this plan, your beneficiaries will avoid paying probate fees on assets that do not require it. So if you're interested in having multiple wills, I would recommend that you retain legal counsel. And then a final note, each jurisdiction and each country has rules it follows concerning wills. And I recommend that you have a lawyer preparing your will to have this in consideration.
Thank you very much, Estella. And that last point is very important because some of us have citizenship in more than one country, right? And some of us have land back home or property back home that we want to bequeath. So, Dora, what elements are in a will? What are the main parts of a will?
Thank you very much for this opportunity. A will is the final document, as my colleague just said, that a person does, that is left when a person dies. In order to have a will drafted, there are several things that one has to have. First of all, it's called the last will and testament. And it starts off by giving the name of the testator. The testator is the person who is making the will. Next, you'll have the name of the executor. The executor is the person who distributes the person's estate. The person's estate, of course, is the effects and the items that the person has acquired, property, etc., during their lifetime. Then you have a part of the will that revoke previous wills that are the same. So if you have another will, you would have that will revoked, and this one might be your last will and testament. And as my colleague says, you can have different wills, but you have to indicate, because if there are two wills running around, there might be some problems in terms of the probating. They might not know which one was the real last will and testament. Then the next thing that you should have in a will is the debts and taxes. Before the executor can do anything on a will, they have to pay all your debts, make sure they collect all your debts and pay all your debts. And of course, taxes and funeral expenses have to be paid. Once that is done, the next part is called the residue of the estate. The residue of the estate is what remains in your estate, what property remains in your estate, and how that property is to be divided. So you'll have given the name of all the beneficiaries, all the people that you want to participate, to get a gift from your will. And when you give the list of the people, you will also have to provide for, just in case that person predeceases you. Predecease means die before you. So if that person dies before you, who would get what they would have been entitled to? We also put in our wills in Ontario what is called a family law clause. The family law clause really basically says that if there is a breakdown in marriage, because under the Family Law Act, assets accumulated during marriage is divided equally. So in your will, if you do not want your assets to go to the spouse of your beneficiary, you would put in a clause that is not to form part of the family property. So your beneficiary would not get any. Then it's important when you're making a will to think about if you have minor children. So you can choose a guardian for your child in the will. You can also set out in the will, and I really don't recommend that people set out in the will their wishes for their funerals, because sometimes wills are not probated or people do not see the will until sometimes after. So if you have to do this, I would suggest that you put that in a letter and give that to your executor. And then what it's also important that once you've got everything, each fact stands on its own. So people might have different things that they want to put in their wills. And then the final thing is that the formal execution of the will, which consists of the testator, and we all know what a testator is, and two independent witnesses, all present at the same time to watch the testator sign her will. Once that is done, the lawyer will do what they call an affidavit of execution, which will say that one of the witnesses saw the other person sign the will in the presence of the testator, who had the capacity to sign the will. And then they will put that on the back of the will, and that will be complete. And of course, once the will is finished, we suggest that people keep their will in a safe place and then tell their executor where their will is.
Wow, thank you very much for that rather comprehensive sort of list of what goes in a will and, you know, all the different considerations. So having garnered all that information, when should a person write a will?
Is that
Estella, this would be for Estella.
Yes, thank you. If you don't have a will in place, please have one prepared immediately after this webinar.
As in now, like
basically, you must have your will like yesterday.
Yeah.
Yeah, so most people, regardless of culture or place of origin, have a fear of making a will.
Mm.
And this fear may originate from myths that circulate when people talk about death, or people just not taking the time to make a will a priority. However, this is going to cost you. Not having your last wishes in place will cost particularly those loved ones you leave behind. So do not wait until you are unwell, as your ability to make a will may be limited, or wait by putting it off, saying that you'll do it at a later stage, at a later age, as your capacity at that time to make a will may come into question. Every adult should have a will, and to ensure that their possessions go to a specific person or a charity of choice. That's why one of the reasons that you need to have a will. And you should have a will in place if your financial circumstances change. For instance, you inherit a large sum of money or win a lottery. Well, now, if you have a will made, have a plan to read it through every so often, every 5 years, 3 years, whatever time you choose, to ensure that your wishes are still the same. This is because there may be some changes in your life. And some of those changes could include the people that are named as your beneficiaries. They may predecease you, right? They may die before you. Or your executors may die before you. You may get married or divorced. You may have children, or the will that you had previously may have specified guardians for your children, and at the time of you review your will, your children no longer need a guardian. Or you may change your mind on gifting. For instance, you may wish to add other people or charities to the will. Remember that the changes that you make must be in writing. They must be dated, signed by you, and also witnessed. If you are to make any changes, I recommend that you seek legal advice.
Yeah, thanks. Thanks for that. So after this, let's all let's all figure out how we'll be putting together our wills. So you talked about the testator and you talked about the executor. How do you choose an executor? Thora, how do
The
you choose an
exec-
executor?
the executor is the most important person that can be involved in your estate planning. The executor must be somebody that you trust. Parents have a way of choosing their children. It is a good thing to choose your children if you can trust that child. If you have two children who are fighting during their lifetime, when you die, they will continue to fight. So it's important that you see in future what might happen once you go. So therefore, it's important that you not only trust the executor, but you make sure that it's somebody that are going to work together. I would advise that when you're going to choose an executor, you sit down and you explain to them, because the role of an executor is quite complicated. They're responsible for all your assets. They have what they call a fiduciary duty, so they have to account for you, for all the assets in your estate. So it's important that the person that you choose, you trust, and also that there might not be dispute between the parties.
Yeah. So how is a will executed? Once you've chosen your executor, you have all the elements of your will. How is the will executed? Thora.
Well, once the will is drafted, the last part is just really the formal execution of the will. You have to have two independent witnesses. The witnesses have to be over the age of 18. The witnesses cannot be the beneficiaries or the executors. Then the two people have to be present when the testator is there. The will is executed if you have 5 pages of the will. The person will sign at the corners of each copy, so they will initial each page. And then on the last page, the person will sign. The witnesses will sign their name and their addresses, and it will be dated. And as I said before, once that is signed, then there's some other formalities that the lawyer carries out, which enables the will to be probated without problems.
Mm-hmm. Yeah, so witnesses.
Yeah.
Oh, sorry.
I will point out, though, that in the formalities that I just set out, the rules have just been changed last March, that the Superior Court, if there are minor discrepancies, there are minor things in a will, then the court can validate that will if certain circumstances exist, and they can prove that that was the actual person that made the will. Prior to that, if there was an error, the will would have been considered invalid and the person would basically be intestate. And that is very new changes that came in last year.
Is that in Ontario or throughout Canada?
No, I don't know about in other provinces. I'm talking about Ontario. So that is what's happening.
Okay, that's very important because we may have people in the audience from other jurisdictions, right? Where, for example, in Quebec, it's a different, legal system.
Yeah, I think that what we are talking about here, because we practice in Ontario, most of the examples we give are from Ontario.
Ontario. Okay, so still, Thora, so how do you prepare to see the lawyer about creating a will?
When somebody calls me and they said they want to see a will, I will give them a list of things that they need to bring and information that they should have when they meet with the lawyer. They need to know the names, the full names of the executors. It also helps to have the address of the executors. And sometimes it helps to have the date of birth, because sometimes people have different names, have the same names, and it helps to have the date of birth. So then you will have the name of all your beneficiaries, the names, their date of birth, and their place of birth. The reason why I'm saying their place of birth is because, as mentioned before, in some countries, people are taxed based on their citizenship and not their residency. So if you have a person that is going to be inheriting in Ontario or in Canada, and that person is an American citizen, what the person inherits might be subject to American tax. So it's important that you find out the nationality of the person. Then you should have a list of all your assets. Not only do you have a list, if you have the list, you should say in whose name the property is in. If you have a house, you should really bring the title document to the lawyer. The lawyer will need to see whether it's joint tenancy or it's tenants in common or any other means of having the house. The house could be, the property could be in the name of a corporation, so that's important to know. Then we have a lot of what they call blended families. You need to know if there was a previous marriage. If there was a previous marriage, then what are the provisions that was made for that previous marriage? And then you need to know the current people. Okay, so you need to have that. Then once you get everything, you have to have your bank accounts, all your assets. If you have insurance policies, you need to let the lawyer know about that, because there might be a different way you want to deal with your insurance. If you have bank accounts, it's important with bank accounts, whose name is the bank account in? Is the bank account in your name and a child's name? Is the bank account, if it's a joint account, you have to be very careful, because people assume that because it's a joint account, there's a right of survivorship, so they get it when you die. The court has ruled that there's a presumption that the joint account, the parent or seniors put their children's name on their accounts for convenience, and therefore it does not necessarily pass to that child. So of course, the lawyer will need to know that, because the lawyer will need to know how to deal with that particular thing. So basically, every single thing that you can think of, you need to bring to the lawyer. And if you have property overseas, then of course, all the documents you have with every property that you have, you give it to the lawyer if there's anything missing. And what most lawyers have, we have a checklist. We'll go down the checklist and we'll ask you all these questions. And then based on that, we can draft your will.
Wow, that's it's involved, but it's worth being thorough and being really well prepared when you go to see the lawyer. So let's say you're a procrastinator like me, and you haven't made a will. What are the consequences of not having a will, Thora?
I look at a will as a will is the voice, is your voice, is the will, is the document that speaks for you when you are not able. The will is the document that sets out how you want your assets dealt with, who you want your assets to go to. If you do not have a will, the first thing that will happen is that in Ontario, they call it that you die intestate. If you die intestate, you can choose a relative and go to the court, and the court can appoint that person to administer your estate. If there's a problem and the people cannot agree, then the court might have to appoint somebody. That is very costly. So first of all, if you don't have a will, it's going to cost you extra because you have to go to that extra part. Then the people that you do not want your assets to go to, it might end up going to those people. So it's important that you have a will. Then if you have minor children, we talked about that before. If you have a will, you could appoint a guardian for your minor children. If you do not do that, the government is going to do that because somebody else will have to step in. Obviously, if there's another parent, that parent might be the one that takes over the role. But again, you have to look at whether these people were separated and where the other parent is. So that is very important. And then we talked about the fact that you might have special funeral arrangements. And again, I would not put it into a will, but when you die without a will, you get buried in a way that you might not want to. And I think about a friend of mine. She wanted to be buried in Jamaica. She's sent everything that she had to Jamaica. She died intestate, and she was buried in the place where she never wanted to be buried, because what she had told her friend is, I do not want to be buried in this cold soil. But because she did not have a will, she was buried in the cold groundland, she called it. So that is important that you have a will, so that then the other thing that happens is, because the division of the will is based on what the government law in that province sets out, you might end up with a will and with your property going to somebody who has been your enemy all your life. You have a sister who you've been fighting with all your life. Because the court divides it, it might end up going to that person. So nobody wants that. If you have a charity that you might be dear to your heart, there's nothing that's going to the charity. If you have particular gifts that you would have liked to go to a particular child, that would not go. And if you have informal agreements, like, for example, if you had an agreement that your grandchild visits you every week, and every time your grandchild visits you, give the grandchild $1,000 a week, a month, or whatever. Because you don't have a will, you would not have made provision for that grandchild or any other informal things that you have. But so if you die without that will, the government might take over and they will look for relatives of yours. In Canada, people are from all sorts of countries. But I don't think that the Canadian government, the Ontario government, is going to go looking all over Jamaica to find out if you have a distant relative. So if in the end, they cannot find anybody that can inherit, your hard-earned assets will be taken, they call it escheat to the crown. So that is why it's important that you make a will, because if you don't, your property might end up going to people that you do not want to go to. And of course, it's very, very expensive to go through the business of having it go through the court. And when a probate would have been much cheaper.
Mm-hmm. Your will is your voice from the grave. That's, I need a t-shirt that says that to encourage people to write their wills. Somebody has a question in the chat that is very interesting that either of you can answer. What is the difference between a will and a living trust?
I do not do trust law, so I'm not going to get into answering that.
Do any of you know?
I know what a trust is, but I'm not going to venture to take that because I really am not quite. If you leave something to somebody for somebody else to do, that is a trust. But trust is very, very complicated, and there are different type of trust.
Okay, Estella.
I'd be careful in addressing this because it will be borderline legal advice if we go into detail on that. However, in Canada, when we're talking about living wills and things like that, we're looking at personal care, power of attorney, and personal care. So that goes there as well. That is included in there. So
Thank you very much for that. And again, I remind our audience that this particular conversation is for information purposes. It's to give you an idea. It's to sort of, get you thinking about, planning to get a will done, and the kinds of elements and factors that you should take into consideration. All right, moving right along. So disputes. We kind of started that conversation about disputes that are linked to wills. Estella, let's talk about disputes and when they arise.
when do disputes arise? Will disputes? There are a number of reasons why these disputes arise. And in the interest of time, I'll speak about 4 of them. So the first one I'll speak to is when there are disagreements among the beneficiaries. For example, when some of the family members wish to keep a family home or a family business, and others want to sell it and share in the profits. This is where you've given your the will that has been gifted is the family has a big home. It's been used as the family home, and the executor, some members split and they say, we want to keep it, and others, because of maybe financial situations, they say they want to sell it and share the profits, and others, for sentimental reasons, may want to keep it and say that this is the place we have. So that's an example, but there are others, disagreements among beneficiaries that come to mind. Another reason disputes arise is where there are allegations of undue influence, meaning when a beneficiary is accused of intimidating or coercing or using blackmail, flattery. Flattery is something that we don't think about, but flattery, somebody can accuse the beneficiary of flattery or deception to the person who's making a will, right? The will maker, that's the testator. The way they write that will, and all these influences are seen as undue influence if at the end of the day it goes against the true wishes of the testator. So that would mean that whoever, other beneficiaries may may say that there was undue influence. It couldn't have been that Aunt so-and-so gave such and such to cousin ABC. They flattered her. They did all these kinds of things. So that's why they got, they coerced her. So that's why they are in the will. So they can say it's undue influence. And it's up to those people who are saying, making those allegations to prove it, right? The third thing I would talk to you about is when a will is deemed invalid. Thora has given you a list of things that need to happen, right? But when the beneficiary call into question the validity of the will, usually there is proof of undue influence. And there is proof that the will maker did not have testamentary capacity. They did not have the ability to make that will. Or they may say that the will maker was considered not to have testamentary capacity at the time. The fourth I'll give you is when the executor does not follow the will. Now, this happens when a beneficiary, who is also named as the executor, transfers assets to themselves, to other people, and whatever they're doing is contrary to what is in the will. So the other beneficiaries at that time may file claims stating that the executor was not following the will because they made, or they may have made, unauthorized transfer of assets. So in a nutshell, that's what I refer to. But there's a long, long list of these.
Yeah, but hence why the executor should not be a beneficiary, right? To avoid that kind of conflict, right? Thora, you had something to add?
The executor can be a beneficiary, for example. If you can choose your husband as your executor, your husband would also be a beneficiary. The thing is that your husband cannot sign the will.
That's the only.
Ah, okay. So you, Estella, you talked about a person's capacity to make a will. So what actually determines that? So Thora, can you speak to that?
It is presumed at law that people have the capacity to make a will. When a person comes in, you have to, if you have to look at, there are 10 questions that you ask, and it's going to base on how the person presents. If a person walks in your office and they do not present very well, maybe you have some questions, but it's not up to us to assume that a person does not possess the capacity to make a will. People, in the main questions that you would ask, if people know about the assets that they have, the value of the assets that they have, the nature of the document they want to sign, who the beneficiary is going to be, and then what would be the consequence of something happening? Do you know that although you have made all these plans, something can go wrong? However, if somebody comes into your office and they do not have some physical signs about that, then there won't be any reason for you to assume that that person does not have the capacity to make a will. In this society, we assume that age is also incapacity. And that might be a very broad statement. However, if somebody comes into your office and that person is 95 years old, you might want to get a letter from his doctor. And the reason is that if the will is made and it does not satisfy the beneficiaries is going to say, because of his age, he would have been easily influenced. So this would not be what he wanted. I had a fellow come into my office the other day, was 95 years old, and that man was so astute, it was unbelievable. But notwithstanding that, I felt that it was necessary to get a medical report done because of his age alone. Once he's gone, somebody's going to argue, well, I believe he could have been influenced. And you look at things like, how did this person present themselves? How did he dress? How did you get here this morning? And you can really find out from this older person exactly whether they have the capacity. It's not up to the lawyer to determine capacity. We can just ask these questions. But if you have any doubt, then you would get a report about the person's capacity. And they have professionals who are specially qualified to do that type of assessment.
Great, thanks for that. Yeah, because yeah, that can end up being used in a dispute. So let's get back to disputes. I know I'm focusing a lot on the conflicts rights and that sort of thing. But can we talk about the phenomenon of parents disinheriting their children or family members disinheriting other family members? Estella?
Well, a will is a document that leaves your last wishes with instructions on what to do with your possessions. It is the will maker's right to divide their possessions as they please. If they choose to disinherit, or if any person chooses to disinherit, be very specific and be very, very clear in how you write your will, because your disinherited children will dispute it. They will dispute your wishes. The family, usually, the family may come up and say, how did this happen? Why didn't we know about this when this person was alive? So your choice, it's your choice to make that decision, but be aware that they will question it. So do you have to say anything about disinheritance to your children? Again, that's your choice. You do not have to, but some people do. In some cases, a challenge to a will may arise if you are to gift a charitable organization and your intentions are not anticipated. Your close family who expected to be beneficiaries will challenge, will come and make a claim against that. Aside from your children, your estate can anticipate a challenge from your siblings and other organizations that may have been beneficiaries in a revoked will. In disputing the disinheritance, the beneficiaries will require answers. And some of the answers we have talked about already, Thora has mentioned, they would be asking, is this will valid? Did the will maker have the capacity to make the will? Were they influenced? Were they influenced by the charitable organization? Were they influenced by anybody to direct that disinheritance? What is the relationship between the people who have been given this gift and the testator? So the short answer is yes, you can disinherit your children. I'll give you a case in called Spence versus BMO Trust Company. And in that case, the deceased had two daughters. He left his estate to one of the daughters. And this was the estranged daughter. The second daughter challenged the disinheritance. The lower court agreed with her and divided the estate equally. However, that decision was appealed in court by the other daughter, and the Court of Appeal judges overturned the lower court's ruling, resulting in that second daughter receiving nothing from the estate. And I want to quote what the appeal court said in their ruling. It said, no one has the right to interfere with a person's distribution of his own estate, even if it's discriminatory or repugnant. Neither the Ontario Human Rights Code nor the Charter, that is the Charter of Rights and Freedoms, a part of the Constitution of Canada, can dictate someone's final private legal bequests. Further, a testator's freedom to distribute her property is a deeply entrenched common law principle and Ontario law accords testators the freedom to exclude children who are not dependents from their estate distribution. So there are many, many cases concerning disinheritance that have gone before the courts. To avoid court challenges, you need to prepare at least a document. You need to be prepared to make a document detailing reasons for disinheritance, such that you give the reason that are valid, rational, consistent with modern Canadian values. So that way that disinheritance is unlikely to be overruled. In case you want to disinherit, seek guidance. If you wish to disinherit your children, make sure that you seek guidance so that your wishes can be honored.
So my next question, we sort of touched on briefly here and there. What can spouses inherit in a will? So that's any kind of spouses, married spouses, common law spouses, same-sex spouses. What can spouses inherit? Thora?
I think that the word spouses is very wide. And we have to deal, first of all, I talk about married people. When two people are married and one person dies, in that case, they have the surviving spouse has a choice to take either under the will or under the Family Law Act. So that person would get 50% of the estate, because under the Family Law Act, after certain calculations are done, they would be entitled to 50%. If the person is divorced, or if the person is separated, they are not entitled to anything. And again, the law changed last year, March. They are not entitled to anything from the estates unless certain conditions were met. Unless they have a court order, or they have an agreement, or there's some other, or there's arbitrations, there's some other ways that they have made provisions for that person, but otherwise they're not entitled to inherit. A common law spouse inherits nothing. However, just because they do not inherit anything, that doesn't mean that that closes the door. They can go to court, and if they are dependent, the court will make provisions for them to pay for will. Same-sex couples, if they are married, the law would apply to them the same way as it would apply to any other married spouse, because same-sex marriage is legal. So we have covered same-sex, we have covered common law, and we have covered people who are living together.
So someone had a question. What if my house is in my name only and my spouse is still alive, but the relationship has been rocky? So can I put my children's names into my will for the house?
You want me to answer that? If you're
Either
married,
of you who feel comfortable.
if you're married, you're married. And that is the end of it. The judge is not going to say, oh, you're fighting all the time. Because if you're married and you do not want your person, you can get a divorce, or you can get a divorce. But if you put the name in your property in your children's name, and you're still married to your husband and you're still living together as a couple, or as people will assume is a couple, that person will be the person to inherit. So you really can't write out your husband out of a will when you're just having fight over coffee.
Okay.
The thing is, if you had that house in your name,
Yeah,
it's in your name alone, and you separated, the property will be divided.
Mhm.
So if you die, the property is still divided, as long as if you're still married.
Did you want to add something, Estella?
No, she's
No?
covered it. Torres covered everything.
Okay. And so my last question, one of you mentioned this much earlier in the conversation, power of attorney. Power of attorney. Is there only one kind? Are there several? Who wants to start that? Estella?
Yeah,
Power
I
of
can start.
attorney.
Yeah. I can start by telling you that a power of attorney is a legal document you sign to give a person of your choice permission to act on your behalf and to make decisions on your behalf. The word attorney in this instance does not mean lawyer. It refers to the person you have given the authority to act on your behalf. The attorney you authorize must be an adult of sound mind who is not a bankrupt. And in Canada, the requirement is that the attorney does not own or work at an extended care facility, but home in which you are resident. I'll break that down later. Each province and territory in Canada has laws that govern provisions that are relevant to the power of attorney. And if anybody here is from the US, it's the same thing. From any other jurisdiction, it's the same thing. In Ontario, which we are touching on right now, there are three kinds of power of attorney. A power of attorney for personal care that covers your personal decisions, such as housing and health care. A continuous power of attorney for property that covers your financial transactions and allows your attorney to make decisions for you, even if you become mentally incapable. And a non-continuing power of attorney for property that covers financial transactions while you're away from home for an extended period of time. Say you get a contract to live abroad and to work abroad, and you need somebody to look after your transactions, your financial transactions. However, it cannot be used if you become mentally incapable, that non-continuing power of attorney. So when a person dies, the power of attorney becomes invalid. The attorney ceases to act in any manner on behalf of the deceased. At this time, the will takes over, and that is now the last will and testament that comes into effect. And the named executor of the will start their duties to administer the estate of the deceased. So who do you want to give your power of attorney to? This is given to, you can give it to your spouse, your sibling, friend, a professional such as a lawyer, accountant, or anybody of your choice. And for this power of attorney to be valid, for a continuing power of attorney for property to be valid, it must be titled, that document must be titled a continuing power of attorney for property, or it must say that it allows your attorney to continue acting for you if you became or you become mentally incapable. It must have your name, the names of one or more persons to act as your attorney for property. You must sign and date the document, and it must be signed by two witnesses in your presence and the presence of each other. The duty of the power of attorney for property is to do your financial transactions, such as banking, paying bills. They can sign checks for you on your behalf. They can purchase or sell real estate or do your income taxes. This continuing power of attorney for property immediately comes into effect after it is signed and witnessed, and then that attorney can use it. With respect to the power of attorney for personal care, this is also a legal document that covers your personal decisions, such as housing and health care. The document, to be valid, it has to show your name as well, the names of one or more persons who are authorized to act on you as your attorneys for personal care in the event you become mentally incapable. That is critical. It doesn't come immediately. It's only when you become mentally incapable. Again, you must sign and date the document, and it must be witnessed by two. They have to put their signatures before you and before themselves. They have to be there. And anyone under the age of 18 cannot be a witness. So you cannot call anybody of that age to be. So the power of attorney for personal care will come into effect, as I said, and be used only during that time when you're mentally incapable of making your own personal care decisions. If you do not make a power of attorney for personal care and you become incapable of making decisions about your medical care or about decisions to a long-time care facility, a family member would automatically have the right to make these decisions for you. If there's no family member or representative who is available or capable and willing, the Ontario Public Guardian Trustee is required to make that decision on your behalf. So my recommendation is have a power of attorney for personal care in place, because you do not know, life happens, you do not know.
Thora, do you have anything else to add about power of attorney?
Again, in terms of the power of attorney, I would say that you ensure that you get a trusted person. And I have so many stories of children selling their houses, their parents' houses, when they are on holidays, and of children selling their parents' houses and putting them in nursing homes, and of children selling their parents' houses and dropping them off in a senior citizens home and they've never seen again. So therefore, the most important thing that you can do with a power of attorney is get somebody that you can trust, because there are too many stories out there. I mean, it's a nightmare what is happening, because the power of attorney gives a person the authority to do every single thing that you would do for yourself. That power of attorney gives that person to go in the bank. It gives them the authority to sell your house. But what is happening, the banks are taking a little bit more caution. What the banks are now asking, that when people turn up with their power of attorney for their parents or their relative or whatever, the bank is asking that they get a certified copy, so that they know that it's coming from, you know, a lawyer, because the lawyer who made it would certify it. But to do that, the person have to present the original copy of the power of attorney, and then the lawyer will certify that it is a correct copy. The other thing about a power of attorney is that sometimes the banks want you to have their copy, their form. Caution is that if they have their form, they might only want to deal with the assets that you have in their institution.
So speaking of trust, somebody has a question about unscrupulous lawyers, because just as you have unscrupulous offspring, children who will sell your house and put you in a home, you also have lawyers who could just decide to take possession of your estate. How do you, how do you guard against that?
Unscrupulous. All lawyers have insurance. I'm not sure how you, if a lawyer sells your property without your authority, the lawyer is going to be subject to the same law as anybody else who steals your property. Secondly, the other part is that you will not be able to practice law again in Ontario. And then thirdly, the lawyers are covered by insurance. So that would be something that they would also look into. But I'm not quite sure what the word unscrupulous means, outside those areas.
Estella, do you have thoughts on that?
Yeah, if you think you are dealing with an unscrupulous lawyer, leave. You have a choice. There's so many lawyers that are out there that you can go to get assistance. Now, that service, if you feel that there's something wrong that has happened, you can report the people or the lawyer to the Law Society, because there's a process. If you you can make a complaint to the Law Society, and the Law Society will do an investigation and look through to see what went wrong, and will be able to support you in whatever way they can. That investigation is very thorough. And what Thora says, that the lawyer will lose their license, is very real. And it happens if at all the person is found to be guilty of doing work. Even sometimes I can go into it a little bit, because sometimes we find ourselves really held to a strictly high standard, and that high standard is expected because of the trust the community has in lawyers. So the Law Society ensures that it will investigate every little thing that comes across the desk. However, that does not mean that you bring frivolous complaints, because if it's frivolous, it will be deemed frivolous, and you may be upset when it's declared frivolous. And if a lawyer is found to have been fraudulent in any way, then of course the penal code comes into play, and they'll be charged like any other person, just like Forrest said.
So one good question I just saw in the Q&A, once you've got your will together, everything is signed, everything is witnessed, etc., where should you store it? Where should you keep your will? At a bank, with the lawyer, with the executor, who, where?
I personally don't keep wills. There are some lawyers who keep wills. They have a safety deposit box in which they keep wills. And I always advise my clients, when I do wills, I send out a letter and I give them all the instructions of if things changes, what they're supposed to do. I also tell them that they should, save it in a very safe place. Usually they could use a safety deposit box in a bank, but I'm not quite sure if those even exist nowadays. But they should really keep it in a safe place and tell their executors where the will is located.
Mm-hmm. Estella?
Some lawyers keep those the wills that they make. My concern usually is, and probably it's a practical thing, what if that lawyer dies or they move or whatever happens to them? Then there'll be that search for the will. Of course, usually the practice of the lawyer is taken over by somebody else, but your relatives would not know that, right? So you have to know the right place to put that will. Make your choice wisely. And yeah, the banks, I don't know anymore. There's the cloud, the technology has advanced to such an extent that there are so many ways we can use to keep our wills. So, but lawyers can keep the will, and they, if at all, what happens usually is if they kept the will, they would tell you when they're shutting down, they're closing their offices, that I'm moving, here are your documents, or they would transfer them to another lawyer, and then they'll inform you that everything has been transferred in trust to another lawyer. If you don't like that, you inform them and you go pick it up.
So keyword, safe place, and let your executor know where it is, right? Those two things. So there's another question. We talked about binational people who have property and assets in different countries outside of Canada. So here's a question. So you have assets in a different country or jurisdiction. You're creating multiple wills to cover the assets in each jurisdiction or country. Remember the checklist at the beginning, does the checklist that the lawyer requires for making your will have to include properties or shares in the other country that don't necessarily need to go through probate in the jurisdiction where the will is being made?
I have that question on my document. It doesn't mean that we will probate that anything there, because obviously, especially when it deals with real estate, the law in each country is governed by the law in that country. But it is something that we ask because we need to have as much information about our client as we possibly can. And of course, okay, I was just going to say, if that person have property in another country and that person is living in Canada and is going to make that person a beneficiary, that could be, the name of that person will be on the will here. The will be probated here in Canada, and the will be sent to, and let's talk about Jamaica. And the will be sent to Jamaica, where it will be resealed. So it will be a much cheaper process than having them do something in Jamaica. So it will be probated here, and we'll just get a copy and go to the courts here. They will reseal it, send it to Jamaica, and Jamaica will deal with it just like that. And that's a cheaper way to do it.
Estella?
I think that's the same process that would be used anywhere else, because you need to, if you live here, but you have properties there, those properties you have itemized beneficiaries to them. So the same process would, because what we forget here is that we are in a common law, like basically our jurisdictions, laws are based on common law. So the England influence permeates most of where most people come from into Canada. So you'd find that what happens in Jamaica, the same process that's happening there is the same process that you'd find in most common law places. So they would receive the will, they'll seal it, and so long as the executor knows about it, they'll be able to open it, to unseal it out in the other country and read it out when it's read out.
So somebody has a question about the cost of preparing a simple, uncomplicated will.
Simple, uncomplicated will. I think it depends on which lawyer. I think people are, if you have a simple will where it says from mother to father and that's it, that will be considered a simple will. So, but if it becomes complicated, you might find that you have to go into an hourly rate, because it's not as simple as people think. And I think that the conversation that we have here will indicate to people that it is not as simple as we think. The person have to meet with the lawyer, take all this information that I've talked about before. Then the lawyer has to draft. No, after you meet with the lawyer, give them the instructions. What the lawyer will do will send out a letter confirming your instructions. You get back that letter saying that those are your instructions. Then the will be drafted, we'll review it with you again, then sign it. So I think that people are running from about $1,000 for a very simple will. A simple will is from husband to wife, and if wife dies, to all the children went down the line, and that is a simple will.
What about single people?
Single people can do their will. Yes, but you see, it doesn't matter who does a will, whether you're single or not. The rules are the same, because when you do a will, whether you're single or not, you have to end up with nothing left in your estate. So even if you're single, you still have to have somebody to leave the final amount to. If you don't, it will invalidate the will. So I usually draw a funnel, and I said to people, you start off wide, and at the end of the funnel, there won't be anything left. So even if you're single, you still have to figure out who is going to go on your will.
Estella, did you have something to add?
Just a little bit. What do you mean by simple? Because things can be very complex. You may think it's simple, but when I listen to what you're saying and what you have to do and how you want things to go, it's complex. And I have to follow certain rules of writing a will that that guide me in making sure that your will is not going to be invalid. And so writing a will may sound simple, and it's been made to look like so because of so many ways you can fill in this, fill in that, fill in the other. But in so doing, you may miss out a lot. So when you bring it to a lawyer and they charge you, you may think that it's too much because you're just giving it to A and B and that's it. But there may be more, because as you talk, when you meet that lawyer, as Thora said, by the time you go through that funnel, yeah, it can be a lot. It can become complex. So simple, I don't know. Yeah.
Exactly. So, and beware of, all of these DIY online, do your own will kind of deals, right? You still will have to get everything certified, witnessed, signed, etc., sealed, and all of that. So somebody, to go back to the power of attorney. Oh, did you have?
Yeah, if at all it's a do your own will, but then it's supervised by someone, then that's fine. But if you just do it yourself, you remember when you get those do-it-yourself kits on anything, you may make some mistakes. And with the will, take it as your last wishes. Take it seriously and make sure that what you want to happen is what will happen.
Thanks for that. So to go back to the whole issue of power of attorney for personal care, somebody has a question about do not resuscitate, when there's some sort of catastrophic injury or, terminal illness, etc. Can either of you speak to that?
I can say that the do not resuscitate is different from the power of attorney
Mm-hmm.
that you give for your care on health. That power of attorney, you're giving the person the authority to speak to your doctor, the medication, the process that you go through. Whereas with the do not resuscitate is pulling the plug basically, and that is something that is determined. Somebody has, it's a different document that you have to sign and tell the hospital that I do not want to be resuscitated if I reach this point. With the power of attorney, if it's critical, your attorney still needs the medical people, two medical personnel to tell, the doctors have to say, they have to sign on to whatever is going to happen. So there's a difference between the two, but Thora may have something to add to it. If
Not really. I don't have anything to add. I'm just looking at some of these questions coming up in the chat.
Mm-hmm. Okay. And speaking of which, and I have that question too. So writing your will by, in your own handwriting, is that acceptable to the court, or does it have to be typed and it has to look really official? Because you hear these stories of people, they wrote, they were in their bed and they were like, and then they, wrote on a napkin or something.
Yeah,
This is my last will and testament.
yeah, well, with the new changes, I think that might be acceptable because it's better to have something in writing than nothing at all. And as long as it meets the requirement of being witnessed by two people, you can write it on anything. So it would be a person in a hospital who writes a will at the last minute and he has it witnessed. The court would accept that because he would not have the opportunity. I don't know what happened in law schools now, but years ago when I went to law school, they would tell us that it was not advisable to go into a hospital and make to get instructions to make a will. So if that person decided that they want to make a will, and they make a will and ask the doctor or the nurses to witness it, that would be considered valid. Because he's met all the requirements.
Estella?
I'll leave it as is.
Yeah. Okay. And one quick last one, and I have this question as well. Access to your digital communications, your Facebook page, your LinkedIn, your email, and all of that. Should you put that as well in your will?
Yeah, because this digital age is very strange. This is becoming property. So I guess that if you put that in your will, then the issue would be that you would have to go to the tech company so that the tech company would be able to give you access to that information. But then because we have photographs and all that type of thing on documents nowadays, so I guess you would put that in your will, but then the step that the person would have to take after that would be they would have to go to the tech company so that they can retrieve that information.
Estella?
Can you repeat the question, please? I was looking at the chat.
It's about digital, like your digital records, your communications, your email, your Facebook, your LinkedIn, your Instagram, after you're gone. Should you put all of that in your will as well?
Yes, in a way, some people prefer to put it because they want to know where it goes, where it's transferred. They want to know who they're giving it to. So it's like giving your digital footprint to someone so that it stays in existence, or if somebody keeps it, because depending on what is in there that you want to share. So Some people do in the wills today. Some people do that.
Mhm. Great. Well, this has been really eye-opening, very instructive conversation. And I'd like to just end with two pieces of advice from the two of you.
I'll start.
Mm-hmm.
My advice is take writing a will seriously. And I would say that where there is a will, there is peace of mind. That would be the first. The second thing I'd say is by having a will, you leave order. And that you leave an order that requires your affairs to be administered according to your wishes. So you rest knowing that there's order.
Laura?
My first advice would be whomever you're choosing to do your will, make sure that you trust that person, because it becomes very expensive when conflict arises and you have to go to the court to resolve them. It's also, and my second advice would be once you're over the age of 18, you should make a will, because nobody, or even a power of attorney, because you never know when you're going to be sick and when you need it. And what I say, if you don't have a will, you don't have a voice. If you don't have a voice, then you really do not have a choice. And when you do not have a choice, you know what happens.
Well, thank you very, very much to both of you, Estella Muyinda and Thora Espinette, for sharing your expertise with our audience. I hope we all learned something, and if we don't have a will, that we will go ahead and plan to make a will. And again, the information that was provided in this conversation was for information purposes, and you really should go and see a lawyer in your jurisdiction for specific legal advice with regard to wills and estates. Thank you very much for tuning in.
Look how far you have come.